morning, everyone. Before I introduce the panel, I want to ask Congressman Scott, we're so happy to see you here this morning, to say a few words to us as we get started. Thank you.
Well, thank you very much. And pardon my voice, it's actually better than it was yesterday. And I want to welcome all the juvenile and domestic relations court judges for being with us, and thank you for all of your work. The work that you do has a profound effect on children. Every time a child or a family comes into your court, it's a life-altering experience, and what you do on their behalf will be meaningful for the rest of their lives. I mean, somebody in traffic court, people come and go, it doesn't make any difference. But when people come into your court, I mean, it's a life-altering experience. And you can send them off in different trajectories, and it just makes a profound difference. But also, in particular with juveniles, and part of the system where you can see everything. You can see the failures of our prevention efforts. You can see the good work in our prevention efforts. You can see the parts of the system that don't work, parts of the system that are counterproductive. You can see children sent to adult court that do not have the support systems that you have, and you are not surprised when young people, particularly with the marginal offenses, get caught up in the adult system, why they're actually worse off, although it makes great politics, tough on crime. I also want to thank the juvenile court judges, the Presiding juvenile court judges for their endorsement of the Youth Promise Act, which takes a proactive approach, getting the community together, getting young people on the right track and keeping them on the right track, rather than waiting for them to drop out of school, join a gang, mess up, and then watch us get into a bidding war as to how much time they're going to serve in adult prisons. You know, if we can get them on the right track and keep them on the right track, it's cheaper, we reduce crime, save money, and so I thank you for that endorsement. And so welcome to Washington. Continue to let us know what we need to be doing to make life better for our families. Thank you very much.
Thank you so much, Congressman. Good morning, everyone, and thank you for attending this briefing on how federally supported judicial training, system reform, research, and education bring best practices to the courts in order to benefit children, families, and communities. My name is Mary Kay Bickett, and I am the CEO of the National Council of Juvenile and Family Court Judges. More than 1,900 judges and other juvenile and family law professionals who confront a variety of juvenile and family-related issues are members of the National Council. NCJFCJ provides cutting-edge judicial education, training, research, and implementation of best practices, and wide-ranging research and evaluation to an estimated 30,000 judges and related personnel in the field. I'd like to thank Congress for continued support of these programs and for providing the organization opportunities to compete for these funds. A special thanks I want to give to Congressman Honda for introducing the Domestic Violence Judicial Support Act of 2012 that will support some work of our panelists that they will be discussing. I'd like to now introduce Judge Patricia Martin to begin the briefing. In addition to serving as president of the National Council, Judge Martin is a presiding judge of the Children's Protection Division of the Circuit Court of Cook County in Illinois.
Thank you so much, Mary Kay. Congressman Honda, thank you so very much for coming. It's a delight to have you as well as Congressman Scott here. So if you would like to come and say a couple words, we'd be more than happy to. He came in and he spoke, so we want to certainly give you an opportunity to say hello as well, sir.
I already did, I was on time.
I can take it from him.
Thank you so much. Thank you so much.
Good morning.
Good morning.
Good morning. It's good to see my partner in crime, the fellow from Virginia. I never argue with him, because I'll never win. He's our chairman for our task force in civil rights in the Asian American Congressional caucus. We're a very eclectic caucus, and we have Latinos, we have everybody, because we don't have enough of me. No, that's not true. I mean, he's been a great addition. But I'm pleased to be here, Patricia. Can I call you?
Absolutely.
Your Honor. I watch all these movies and permission to approach the bench. Things like that. So, you guys got some work, huh? Reauthorization of Violence Against Women Act. We're participating in the sense that we know that the reauthorization can be chopped up and things like that. So we want to make sure that a piece in there stays in there or gets focused on, and that's the ability for us to provide more training in the area of youngsters. And the training hopefully will have some judicious effect, some effect on the court proceedings where youngsters won't lose time in school. I get the sense that sometimes when we look at domestic violence, we zero in on the adults with the concern for youngsters, but sometimes it doesn't include their need to be in schools. So hopefully that this will heighten the sensitivity and the need for our youngsters to be able to go through this process without losing time in school. So our goal is that we'll probably hopefully save about 7 months school time, seat time in the school, so that the youngsters don't get too far behind. It's hard enough as a school principal. I know that working with youngsters who are not in class, it gets difficult, even more complicated, besides the life that they're going through, keeping up with school. So it'll be very, very helpful. And hopefully that this will be our contribution to the authorization. So I just want to thank you for this time, and I'll be willing to ask any questions that you're afraid to ask Bobby. Because I'm not afraid of you. Okay, thank you for your work, and hopefully that we'll be able to move this forward. Now keep my eye on Bobby so that he'll be my touchstone. Okay? Thank you.
Thank you, sir. Ladies and gentlemen, I'd like to echo the welcome to the National Council of Juvenile and Family Court Judges briefing on courts' practices, programs, and improvement to the juvenile justice system for children and families. We are co-sponsoring this briefing with some of our friends whom you met this morning, Representative Scott, Representative Honda, Representative Gwen Moore, Representative Karen Bass, Representative Shelley Berkeley, Representative John Conyers, Representative Chaka Fatah. I'm sorry, I apologize. Ladies and gentlemen, I want to take a few moments to give you some information about the National Council and our mission and what we're doing on the Hill this week. But I also want to introduce you to some of my colleagues who are also going to give you examples of what the money that you are bringing to the states actually does and what it results in on the ground in our courtrooms day in and day out. And I'd like to start by telling you a story about Kiana. Kiana is a young woman who started in the Cook County Juvenile Court system at the age of 14, about 20 years ago now. I met Kiana. She was doing very well in school. She was adopted out of our system at a very young age, like 3 or 4. And she was now in our system at 14 again because her adoptive mother, who is her maternal aunt, was getting remarried. And Kiana was not getting along with this perspective and new father. And so the issues of and allegations of sexual abuse and inappropriate touching and those kind of things that we're familiar with hearing day in and day out were occurring in the home. And so the adoptive mother decided that it was best for Kiana to go back into foster care. And what I'd like to ask you, have you ever seen a young girl, a beautiful young girl, walk into your courtroom with total affect. She had no sparkle in her eyes. The thing that amazes me day in and day out is that I walk into my courtroom and I see young people who have no hope. And the way I know they have no hope without even saying one word is they have no sparkle in their eye. And so I start talking with Kiana. She was making A's and B's before coming back into foster care, and all of a sudden her grades went to straight F's. And so obviously something's happening. The workers in my county always tell me, Judge Martin, you just don't understand. Well, I understand something's happening. I might not understand what it is, but something's happening. So I spoke with Kiana, and then she started running from replacement. And so I was having a difficult time trying to get Kiana to understand that if she just called me before she ran, I might be able to do something. So I ended up doing the one thing that I would advise you never to do, and that is I gave her my cell number. So I would get calls at 2 in the morning because some boy didn't talk to her in school, you know, she doesn't have green socks to go with her tan, you know, stuff that, good gosh, I mean, how was I ever going to deal with all this stuff? But nevertheless, so Kiana and I developed this relationship, and I got in the habit of kind of picking up Kiana on weekends, and we would have lunch and go to a movie and all this kind of stuff and talk with her. And just as a real aside, I never realized that when I asked Kiana, where did she want to go eat? And I'm thinking of a restaurant where you sit down and eat. And I said, and so I was trying to get her in the mood of thinking about a true restaurant. She goes, and so I said, well, a place that has napkins. And she says, okay, Subway. and I laughed too. But the reality is that was Kiana's world. Subway was a restaurant. So we went to Subway and we were talking. And how many of you are familiar with the Lynx? The Lynx is an organization of historically black women and spouses of professional blacks who started way back in the 50s or 40s or something. And these women have fashion shows to get up money and fundraising to do civic activities within the black community historically, but now throughout our nation. And so they always have local media talents there and all this stuff. So all these women come dressed to the nine. You know, they get their nails done, their hair done, all these minks and stuff. And so my aunts are Lynx. And so I had to sell tickets. So I bought a ticket for Kiana. I figure if I have to go, she has to go, right? So anyway, Kiana and I go to this luncheon, and I tell Kiana, I ask her, does she have anything to wear? And I'm real sensitive about this because I don't want her to assume I think she doesn't have something sufficient to wear. But I also want to give her some leeway in what she wants to wear. So the idea was I would take her shopping and I would get her something. And she goes, oh no, Pat, I have something to wear. And I said, great, fine, you know, whatever. Well, she comes in a black slacks and a black vest with a white top, which was fine, except she looked like the waiters, you know, who were waiting on the tables. And so throughout the luncheon, I'm telling Kiana about, this is the person from Channel 5, I want you to meet her. And my whole idea was to teach Kiana that every one of us puts our slacks on one leg at a time. Every one of us is a person underneath, no matter how much jewelry, how many furs, whatever our title is, we're just people, and she can do it too. That's my lesson here. And of course, since I'm telling you the story, it obviously didn't work out very well. Kiana, when I got in the car after the luncheon, first of all, she was hungry because she didn't like the food that I paid $100 and something for. So we had to go get some food. But then the other thing was, she didn't like any of the clothes at the fashion show. Now this is a 19-year-old girl not liking clothes. So I'm really trying to figure out what's going on here. And she said, well, you know, Pat, those clothes look like your clothes. They look like grandma clothes. There's nothing showing. You don't have your skin showing and all this stuff. So I said, okay, this isn't working well. The point of my story, though, is that Kiana left foster care at some point. And Kiana, and my agreement with Kiana was that she had to graduate from high school, and she was interested in nursing. And I found a foundation that was going to support her financially through nursing school. And I was working on that, making certain things were all lined up. Well, Kiana called me after she pulled herself out of school and said, Pat, I just can't do it. And I said, Kiana, what do you mean you can't do it? You can do this. I know you can do this. Why do you say you can't do it? And she said, I'm pregnant. And so I didn't mean to, but obviously I was disappointed. And so I guess she heard it in my voice. voice. And she said, Pat, I know you don't want to talk with me anymore, and I know you don't love me anymore, so I'll stop calling. And I said, oh, wait a minute. No, you're misunderstanding. That has nothing to do with my love for you. I love you no matter what happens. I said I was hoping that you would not get pregnant until after we got you out of nursing school. And I said, this is a setback, but we can deal with it. And she said, well, I think I'm successful. And I said, I know you're successful. And she goes, no, you don't understand. My mother was pregnant at 14. So I didn't get pregnant until 20. That is a success. And I had to really sit back and say, you know what, Pat? You hypocrite. You talk all the time about taking your kids where they are. And Kiana's showing you where she is. You spend all this time with her, and you're still trying to impose what you think is success upon her. Now, today I'll have to tell you, Kiana is not in nursing school. She has a child. The child is doing well. The child is not in care. Kiana is doing remarkably well with her son. But again, she heard in my voice the disappointment, and she automatically associated that with, she lost my love. And I'm here to tell you what my kids need more and more than anything else. And we can talk about the laws, we can talk about strategies, we can talk about programs, we can talk about evidence-based programs that we know that work, but what my kids need more than anything else, they need a rock in their lives, someone who loves them no matter what happens. And so I would ask you to continue thinking about Kiana as you go through your day, when you're talking about the laws, when you're thinking about what our kids in our nation need. Please remember our Kiana examples, because rightfully people would consider her a success on some level. And Kiana's teaching me more than I've ever taught Kiana. So I guess I'm actually need to really take care of me. Kiana's got her life together more than I do, I think. But please keep Kiana in mind. Ladies and gentlemen, with respect to the National Council of Juvenile, excuse me. Oh, I apologize. Thank you so much. I'm sitting here looking right at you. I was looking right at you. Sorry. I truly do apologize. Ladies and gentlemen, please welcome with me one of our partners, Congresswoman Gwen Moore. Please, ma'am, would you come up and please say hello?
Sorry. Oh, welcome everybody. It is so good to have you all here in Washington, D.C. and in the Capitol. And please don't apologize, Judge Martin. I was really getting into Kiana and her story, because it is just one of many stories that I want you all to relate to as you go about your court practices and programs and improving justice for children and families. I am so delighted to be here, and I want to acknowledge my good friend, Bobby Scott, who's been a mentor to me mostly on budget issues, but I know that he is an expert in judiciary issues. I come to this particular issue not only as a legislator, but from an experiential basis. I was a Kiana. I was pregnant on my 18th birthday. And became the mother of 3 children. I had my first child at age 18. She actually was in foster care in my sister's home as a foster child, because I wanted to go to college. And back in the day, they wanted to count tuition money as income, so that I was deemed to be ineligible to go to college, because I was on AFDC. So they put my child in my sister's foster home, busted me in my sister's home in my pajamas, busted me, and so created quite a bit of problems, because she's supposed to be in foster care and not being with me. And really sort of forced a separation. I had to go get my own separate apartment and so on, so that my daughter could have the services that she needs. I also was in the state legislature in Wisconsin when then Governor Tommy Thompson ended welfare as we know it, and then that initiative came to Washington D.C. and of course remember good old Newt Gingrich, Bobby Scott, you may have been here, Bill Clinton, this bipartisan unholy alliance where they ended the entitlement for welfare for women and children. And so I think that this has spawned a real phenomenon that I want to bring to your attention. I'm sure it's already to your attention, but there is a real association of maltreatment and neglect with poverty. I know that our laws stipulate that you're not supposed to remove children from their homes because of poverty, but it is very difficult for there not to be some maltreatment that occurs when parents don't have resources. And I could give you a lot of statistics and data around poverty during this last recession, but time won't permit that. But I can just tell you that 78% in 2009, 78% of the children across the country that were victims of maltreatment were also found to have been neglected, and that economic hardship was one of the key factors thought to be associated with reports of child neglect. Half of the families, 47%, who have their children removed from their homes have problems paying for basic necessities, rent, food. And it's important that we have a system that distinguishes between conditions of poverty and abuse and neglect. If you've got your electricity disconnected, my sister often talks about how she belonged to her church mission, and they would proudly march up to a poor family's house with a turkey, only to find that they had no gas and electricity. They couldn't even cook the turkey. And as Judge Martin pointed out, removing a child from his or her home is traumatic for the child. We're supposed to be operating in the best interest of the child. And in many cases, foster care is a poor alternative for preparing a child for adulthood. And I know that Bobby Scott has talked to you about the cradle to the prison pipeline. I knew that you'd help me out here. And foster care is one of the stops on that road. Because people don't have the clever kind of foster care system I set up with my sister. That was her. She got a foster care license to take my child so that I could stay at school, only to have been busted doing it. But we have programs through the Violence Against Women's Acts, the OJP funds, and the Court Improvement Program that are essential to giving courts a small but effective amount of resources they need to improve the well-being of children and families. I have a bill that increases the Court Improvement Program for parental representation. If, it's HR 3873, it would provide seed money to the courts to provide parents with high-quality legal representation. There's a very serious problem in our system where parents have to navigate the court system in child welfare cases, and the state, of course, has all the resources. They can provide a guardian ad litem for the child and provide no legal representation for a parent who's about to lose their child. And I think that there is a growing national consensus toward ensuring that parents are afforded legal representation across all stages of child welfare proceedings. I can't think of anything that was more important to me in my life than maintaining custody of my child. You know, that child is now 42 years old. She called me this morning, "Mama, what you doing, Mama? Where you at?" I mean, we needed each other. And it was because I had other adult intervention to try to keep us from being separated, because I had absolutely nothing except a scholarship that didn't really put any food on the table. Several states have already tried this quality representation. There are models like the Center for Family Representation, Inc. in New York, the Washington State Office of Public Defense and the Detroit Center for Family Advocacy, they've seen remarkable accomplishments in preventing children from unnecessarily being removed from their homes and entering foster care and reducing the amount of time that children spend in foster care. I have an advocacy group in Milwaukee called the Welfare Warriors, and I have to mention them. They fight what they call child abductions because they have seen the faults and flaws in the system where children are just taken from their homes, where poverty is the main problem, and that, you know, were we just to give the kinds of things that you're talking about, some support to the family, so that the mother could get a job, she could have adequate daycare, adequate support, we can truly do what's in the best interest of the child and let them stay in their homes. Thank you so much for this time, and carry on. And really, I hope that you're going to have a good meeting here in DC. Thank you.
Introduce Ashley McDonald, who is the Judicial Committee staff, and Bobby Vassar, who is the lead counsel on the crime subcommittee. And he is probably the most knowledgeable person on crime policy. And so we've been here.
Thank you so much. Ladies and gentlemen, I neglected to also inform everyone that we are taping the meeting today, as well as Capitol Police are here to provide the security for our meeting this morning. I'd like to just touch on two things, and then I'm going to start introducing you to my colleagues. First of all, with respect to the National Council of Juvenile and Family Court Judges, we are one of the oldest organizations in the United States training judges on specialties such as juvenile justice, child protection, family violence, family law. And what we do is go in and supplement the basic training that judges get within their states. State budgets are shrinking and they need more specialized training for these particular areas. And that's where the National Council comes in. Since 1999, we have trained more than 245,000 judges, magistrates throughout our nation on these specialty issues. I know that you know, as Congressman Moore was just indicating, that our children experience trauma. Even when you remove a child who is threatened with and faced with death, when you remove them from that home, that is trauma. Our families have an abundant amount of violence and trauma that they deal with on a day-to-day basis. One of the things our judges are learning about is how to provide services and make certain that community-based services address these issues for our children and for our families. One of our signature programs at NCJFCJ is the National Judicial Institute on Domestic Violence. It's developed and administered in partnership with Futures Without Violence and the Office of Violence Against Women. And you will hear many of us talk about the need for the reauthorization of VAWA this week, and we are very supportive of that reauthorization, as well as many of our friends who are represented here today and in partnership on this briefing with us. Before I sit down, and I did have some more remarks I wanted to make, but before I sit down, I'd like to make certain that I point out a couple bills that are very, very important. The Council, the National Council of Juvenile and Family Court Judges, is a very strong supporter of H.R. 3979, the Domestic Violence Judicial Support Act of 2012, introduced by Congressman Honda, the gentleman we spoke to just a little while ago, as well as S. 1925, the Violence Against Women Reauthorization Act that we talked about earlier, co-sponsored by its bipartisan support, Senators Leahy and Crapo. And I understand bipartisan support is the big thing around here these days, so I want to make certain I include that. Ladies and gentlemen, one of the things that these bills really do authorize and provide for the judges that you see today, representative of all judges across the nation that do our work, is an understanding of the dynamics of family violence and child custody cases. And when I say child custody, that means in domestic violence cases and divorce cases. Those are cases that deal with our children, and we don't forget those judges and those practitioners in those areas. In child abuse, truancy, delinquency, and even elder abuse. And with that, I'm going to cut my remarks a little shorter so that I can introduce you to my colleagues and provide an opportunity for them to give you some of their Kiana stories, if you will, so that you can have a clear understanding of what we're trying to do in our courtrooms day in and day out. I'd like to first introduce you to Judge Karen Howze. She is a member of the Board of Trustees of the National Council. She also serves as a magistrate judge in the Superior Court of the District of Columbia. Karen, if you'd like to join me. Well, you can stay there if it's easier.
Well, good morning, everybody. Good morning. It really is a pleasure to be here. These bills are so important to our society. I'd like to start by telling you all a story that many of you may remember because it happened just over the line in the state of Maryland. This is a story of Dr. Amy Castillo. Her case does illustrate the importance of judges truly understanding the nature of domestic violence. Dr. Castillo is a pediatrician. In 2007, she spent 15 days in a district court in Maryland trying to get a protective order against her abusive husband, Mark Castillo. The doctor testified that her husband had been involuntarily admitted to a psychiatric hospital for a suicide attempt. She also testified that he had recently exhibited manic behaviors. On January 10th, of 2007, despite the testimony that she provided, including the fact that Mr. Mark Castillo had threatened to kill their 3 children, the judge did not grant a permanent protective order on the grounds of insufficient evidence. On March 29th, 15 months later, Mark Castillo had a custody visit with his children, took them to Baltimore, and drowned Anthony 6, Austin 4, and Athena 2 in the hotel bathtub. This is a graphic story. We can't say here who was right, who was wrong, but it says that these cases are very complex, and they require that there is and will continue to be a pressing need to have consistent quality judicial training so that those complexities in these cases can be addressed. The judge in her case needed to know how to issue an order that de-escalated the violence, issuing a stay-away order so that the police could enforce it. Supervised visitation might have been an option that would have saved the children. And structuring a schedule of compliance reviews in the court would keep tabs on how this family and Mr. Castillo was behaving. These are all best practices that judges need to know about to prevent tragedies. These are best practices that the Violence Against Women Act Court Training and Improvement Program provides. We know that domestic violence touches many families in our courts, and that is regardless of what door the case comes into the courthouse. It could be abuse and neglect, domestic violence unit of the courthouse. It could be child custody. It could actually be probate. We also know from research that child abuse and domestic violence frequently co-occur. Studies estimate that in 30 to 60% of families experiencing one form of family violence, the other is present as well. Additionally, studies suggest that in divorces marked by high conflict and ongoing disputes about custody, child support, child care, there is often a history of domestic violence that may not have been documented prior to that case coming open. Researchers also tell us that adolescents who have grown up in homes where domestic violence is present are more likely to attempt suicide, abuse drugs and alcohol, run away from home, engage in other delinquent behavior, and commit sexual assault crimes. A study conducted by the Office of Juvenile Justice and Delinquency Prevention of the Department of Justice found that 70% of adolescents who lived in families with domestic violence self-reported violent delinquency compared to 49% of adolescents from households without domestic conflict. These are sobering statistics. One of NCJFCJ's signature programs is the National Judicial Institute on Domestic Violence, developed and administered by the Council in partnership with Futures Without Violence and the Office of Violence Against Women, again, of the Justice Department. VAWA has been funding this program and training for more than a decade. The National Judicial Institute's judicial education programs help our judges respond to the needs of children who have witnessed domestic violence while also helping adult victims seeking protection in court. Judges play a critical role in the enforcement of protection orders. Judges estimate that without some type of compliance review, upwards of 75% of respondents will continue to abuse. Again, sobering statistics. When judges are trained in best practices around enforcing these orders, judges' right, monitoring abusers' behavior, and holding offenders accountable, the word gets out in the community and recidivism drops. Again, safety becomes the issue for the judge monitoring these cases. Solid research, evidence-based research, tells us that these practices save communities money in the long run in domestic violence and stalking cases. A recent report by the National Institute of Justice summarized the impact of the work of courts in Kentucky. This study found that Kentucky's courts, by issuing and monitoring protection orders in domestic violence and stalking cases, saved the state of Kentucky $85 million in averted justice system and social system costs in just 1 year. Evaluation demonstrates that the VAWA-funded National Judicial Institute improves judicial responses to domestic violence. Approximately 500 judges who had participated in these judicial education workshops reported significant follow-up improvements in their judicial responses in their local courts and communities. A few examples. 2/3 of the participants said that this judicial education provided them with the tools they needed in domestic violence cases. Almost all of the participating judges indicated that the training helped them enhance victim safety, one of our primary goals as judges. The vast majority of judges indicated that the training helped them enhance their efforts to hold batterers accountable. The participating judges also indicated that they had a better understanding of how cultural considerations factored into structuring appropriate sentences or civil remedies. The majority of judges also reported that this judicial education helped them improve their judicial leadership in their community. As a top leader of a local justice system, each judge affects the lives of thousands of community members and influences dozens of justice system professionals annually. Think of the impact we could have provided to all of our nation's courts with similar training and resources. Before VAWA judicial education was implemented, too many courts simply issued emergency protective orders with no further follow-up. Now the courts that have had the benefit of VAWA's National Judicial Institute training have the tools they need to ensure that all relevant divisions of the court, again, family, abuse and neglect, probate, are engaged in keeping the community's families safe. We support Congress's reauthorization of the Violence Against Women Act this spring. The Lehigh-Crapo bill, which was just voted out of the Judiciary Committee in the Senate, recognizes the unique role of judges in helping family violence victims find safety and holding accountable those who use violence against family members. This is cradle to grave work. This bill recognizes that judges provide leadership in their communities and that they are often the only professionals able to pull together resources from public agencies and the community. Judges do have a unique responsibility in our nation's communities. We take it with a great deal of sobriety. Courts are at the forefront of state and local efforts to keep families and communities safe. Without the support of VAWA courts programs and provisions, the training resources and community coordination needed to appropriately address family violence will not continue. I urge you to bring this message to the members of Congress you work for. Support the swift reauthorization of the Violence Against Women Act now.
Thank you so much, Judge Howze. Ladies and gentlemen, you hear often that we talk about the principles or the key principles of the National Council. I want to, at this time, direct your attention to our website, which is www.ncjfcj.org, and you will see our key principles. One of them, obviously, we've talked about a little today, and that is make certain that kids don't and are not removed from homes unless it's the absolute last resort available. Make certain that we do diligent searches to find all parents, even paternal parents and paternal sides of the family for our children. And there's a list of key principles. So when you hear those key principles, that's what we're kind of talking about throughout our meeting this morning. I now would like the privilege and opportunity to introduce my dear friend, Judge Michael Nash. Michael is the president-elect of the National Council of Juvenile and Family Court Judges, and he's also the presiding judge of the Juvenile Division in Los Angeles Superior Court, California. Mike?
Thank you. Good morning, everybody.
Good morning.
A number of years ago, in our court, one of our courts, we had a little boy who was languishing in foster care, and at the same time he was also dying of AIDS. And he had very little hope of survival. Just post that away further here. Our judge decided that we can do better than this. This was, we're not going to just let this boy die without a fight. And so what she did was she enlisted one of our great partners, our CASA program, court-appointed special advocates, and said, we need to find something that's going to help this boy. The CASA, actually, it was a husband and wife CASA team, worked worked with the attorney of the child, the social worker, the child's doctors, and identified what was called, at that time, an experimental treatment. The court ordered it, and the boy's health miraculously improved. Along the way, this dynamic CASA team brought to the court's attention the fact that there had been a previous potential caregiver who was discouraged from having contact with the child because of his illness. The judge said, no, let's see if we can work with this person again, and lo and behold, that person ended up adopting this boy. Sadly, he eventually succumbed to his illness, but not before he had what every child who was ever brought into this earth is entitled to have: a safe, permanent, loving home. Now, a number of years ago, Martin Luther King Jr. said, one of my favorite quotes, "As long as there is poverty in the world, I can never be rich, even if I have $1 billion. As long as diseases are rampant and millions of people in this world cannot expect to live more than 28 or 30 years, I can never be totally healthy, even if I just got a good checkup at the Mayo Clinic. I can never be what I ought to be until you are what you ought to be. This is the way our world is made." Now, it is precisely this attitude that juvenile and family court judges need to bring to work every day. We don't just call balls and strikes in our courtroom or decide who did what to who. Congress gave us the responsibility of oversight over our child welfare system to make sure that it serves children and families in the way that it was developed to or designed to. We can never be satisfied as long as one child fails to be protected and served in a way that gives that child a chance to have a healthy, productive life. No organization has done that better than the National Council of Juvenile and Family Court Judges in training judges and in imbuing them with that attitude and spirit that is necessary to do this job successfully. Congress has recognized that for too long, and we can't afford to turn back now. Let me explain. One example is funding from the Office of Juvenile Justice and Delinquency Prevention, OJJDP, one of our great partners, thank you, supports the Child Abuse Training for Judicial Personnel project that has historically funded NCJFCJ model courts, which are now located in over 70 local, state, and tribal jurisdictions. The project has a proven track record for saving significant federal dollars by safely reducing the number of children in foster care while improving outcomes for them. The model court programs in Los Angeles, Chicago, and New York City alone have successfully contributed to the reduction of over 60,000 children in foster care during the last decade. Had these children remained in foster care, the cost to the federal government would have been over $1 billion. Model courts are able to achieve these reductions through collaborative system reform efforts, not only in the courts, but also in the child welfare agencies and other system partners. Interdisciplinary teams led by judges are the foundation of the model court approach to problem solving and reform. These courts have become the laboratory for the development of evidence-based practices that are then disseminated nationally through training and technical assistance. One of our other really good examples is a program that began in 2008 when our model court lead judges across the country identified the overrepresentation of children of color in the child welfare system and the disparate outcomes they experience, and we identified as that as the most important issue facing them in their courts today. As a result of that, a bench card was developed by the National Council through its Courts Catalyzing Change initiative, which is funded in great part by our good friends from Casey Family Programs. And judges use this bench card at the very first hearing where children are removed from their home. In Los Angeles, Portland, and Omaha, judges have stepped up to allow researchers to measure whether use of the bench card does have an effect on foster care placements. After a rigorous research study, the bench card has been established as an evidence-based practice, the first of its kind from the bench. 45% more children went home to their parents at the first hearing. We have not seen any increase in recidivism numbers in these jurisdictions. While the bench card itself cannot reduce disproportionality given the numerous decisions made before a judge even sees a case, it has been shown to have an impact on disparate treatment experienced by children of color and their families, and we're now in a process of implementing this bench card throughout the United States. In 1998, in Los Angeles, where I'm from, we had a backlog of about 6,000 children who had been freed for adoption, and they were waiting for their adoptions to be completed, and it was almost an endless wait. In order to reduce this backlog, once again piggyback on some of the lessons learned from the National Council, our court partnered with our Department of Children and Family Services and two advocacy organizations, the Alliance for Children's Rights and Public Counsel Law Center. The court provided more courts and court time for adoptions. The department provided more social workers, and the advocacy organizations provided pro bono attorneys to assist the families. Because of this project, since 1998 in Los Angeles alone, we have completed between 30 and 35,000 adoptions from our foster care system. It has helped to reduce our numbers of children in foster care from over 52,000 to about 25,000 where it is today. Early in 1998, we tried a little experiment. We conducted adoption hearings on a Saturday. It was a huge hit. I shared that program with the National Council of Juvenile and Family Court Judges Model Courts in 1999. That program has now grown to a program called National Adoption Day, which has been in place for over 10 years. Each year on the Saturday before Thanksgiving, over 200 courts in all 50 states open their doors and complete between 3,000 and 4,000 adoptions of children from foster care in one day. Most recently, Judge Connie Cohn from Des Moines, Iowa, began celebrating family reunification with a picnic in her jurisdiction. That idea, once again, was shared with the National Council of Family Court Judges, and it is now morphed, along with the help of our good friends and partners from the ADA, to now National Reunification Day, or in Los Angeles it's National Reunification Week, and I believe this year it may be National Reunification Month, where we actually celebrate those families that successfully navigate the often complex child welfare system and cure the ills that brought them before the courts and our system, and ended their relationship with our court and our departments in a healthy and safe way. This is the beauty of our organization, the National Council of Juvenile and Family Court Judges. Thank you.
Thank you so much, Mike. And ladies and gentlemen, now I'd like to take the privilege of introducing my dear friend, Judge Karen Adam. Karen is a former member of the Board of Trustees of the National Council of Juvenile Family Court Judges and currently is serving as the presiding judge in Pima County Juvenile Court, Tucson, Arizona. Karen?
Thank you, and I'm honored to be here with all of you and with my colleagues on the bench. And I'm delighted to be the closer of this discussion and pull it all together for you by describing how we are pulling it all together in terms of the National Council, in terms of the work in our courts, and actually even in this VAWA reauthorization bill with the consolidation of many separate programs into one program, which will hopefully allow courts like mine to apply for funding to do many different things at once. Traditionally, what has happened in courts, what has happened here, and what has happened at the council is that we have been siloed. We have been either child welfare or family violence or juvenile justice or family law, name it, all the other aspects. We've been working very hard at the council level to put together those efforts, and we're working very hard in local courts to put those together, and I'm delighted to see that that is happening, beginning to happen here as well. The council project is called Project One. I'm going to tell you about one court's effort to facilitate the combination of cases among benches. We are not a unified family court in Tucson or in Arizona. We have pilot projects. There are really very few truly unified courts in the country where all issues facing a family are dealt with. What we all know is that the families we see do not come to us with one issue. If anybody has that family, we would all love to deal with that family. Instead, we are dealing with a myriad of issues for our families. I started a unified family court in my one division when I was in Superior Court doing family law. I started in 1981 in the limited jurisdiction court and was right really at the beginning of the attention paid to domestic violence. 1982 is when we first had orders of protection in Arizona. And then I spent time in juvenile court, 10.5 years in family, back at juvenile, and finally I get to be in charge, which is really exciting and scary for the people I work with, because I have 27 years worth of ideas of how to change the system. When I was in family law, I had a case come to me that was a divorce. And I went in, I thought it'd be easy to do, 5 minutes. And I got in there and found out that it was a divorce indeed, but the custody of the children was with the grandparents, the paternal grandparents, coming from a CPS or child welfare case at juvenile court and then going to a guardianship in our probate division. The mother had a court order for mental health treatment. There were 2 orders of protection. There was a civil proceeding because their home was being foreclosed on. It was a big fat mess, as we say legally. I pulled all the files together. I called the other judges, not surprisingly, when I said I'd be happy to handle all of these. I didn't get a single declination. And I was able to have the family in there, appointed a lawyer to represent the children. Both of these parents were not represented by counsel, which is extremely common. You probably all know that in about 85% of family law cases around the country, at least one of the litigants is not represented. Another huge issue. I'm really, really excited about Representative Moore's bill and the efforts to increase the aptitude and the competency of the lawyers who represent parents. And I would love it if we could sometime have representation for parents in family law as well. At any rate, I did it. I pulled everything together, resolved the case. I then went down back happily to juvenile court and immediately recognized that we needed to do a better job about what I consider to be crossover. The crossover movement is traditionally juvenile delinquency or juvenile justice and child welfare. In my opinion, you cannot talk about these children without talking about children who've been exposed to high conflict and or family violence in a family law case, separate orders of protection cases. I just don't think you can talk about crossover without really talking about all the systems. And so that's what we're doing. We began a series of protocols working with our colleagues on the family law bench. We did this with no money. We worked out a way to have our child welfare cases end with, when reunification happened, a valid and enforceable family law order. We have paternity established in every case. We are really, really intent on engaging fathers from the beginning and making sure that they are identified, that they are involved, and that when safe for children and safe for mothers, they are able to work on agreements to resolve cases. We've done an extraordinary job. Engaging fathers allows us to look at a myriad of other placements and support services and relatives and people who can be helpful for children. Many of these relatives have been involved, and it's a case of making sure that people are identified. One of the important things about doing a unified system like this is that the judges, especially the judges that have been trained by the National Council, and I've had most of the training that's offered, and so have most of the judges on my bench. We are a model dependency court and also a model juvenile justice court, is that we can spot issues that not everybody else can spot. When we started doing this overlapping approach, what we noticed was that victims' rights were not being protected. If there was domestic violence in the case, CPS's intent was get everybody together in the beginning of the case, get everybody in the same room, absolutely violating the victim's rights of the victim of domestic violence in cases where that was present. So we've been able to shed light on important issues. Everybody is working with us delightedly. The judges are more than willing to separate cases if we need to have separate hearings. So it takes someone in a position of leadership to point out those issues and to make everyone aware of the importance of the overlap. I thought I would tell you, give you an example of one of these cases. This is a direct quote from a transcript. It was the final dependency hearing, which is child welfare. I was closing the case. The children had been returned to their mother. They had all been involved in domestic violence therapy through a shelter, which was funded by Howze. And their lawyer is actually someone who worked in a shelter and was a domestic violence advocate before going to law school. She has special expertise and knowledge about the case and told me about the program at the shelter, which was for children exposed to domestic violence. There is nowhere near enough of that kind of treatment, kind of support available in most of our communities. We're lucky enough to have it. I was lucky enough to hear about it, and these kids were lucky enough to go. This case involved closing out with a sole custody order in the mother, parenting time in the father, supervised parenting time. We worked with our friends on the family law bench and arranged for supervised visitation so that when the case ended in juvenile court and went back to family law, it was all set up for everybody to have a forum, for both the mother and the father to have the ability to go in and ask for changes to custody, parenting time, the level of supervision, and so forth. I asked the kids come to court. I want all the kids to come to court in my child welfare cases, and I think it's really important for judges to see their children, to think of them as people and not just an issue or a problem or something that must be dealt with. And again, we work to make sure they come when they're comfortable, that if they need to come and there's not a parent there, one or the other, we arrange for that. I asked how things were going, and this is what the 12-year-old said. It's a benefit for the whole family. I think after all this, all this stuff we've gone through, we've grown so much as a family, you know what I mean? So it's kind of like, how they say God has a plan for everything? So I think our plan was to get our family closer together, and that's what CPS has done. I've read that to the CPS workers because they don't hear that very often. Help us get our family stuff together, therapy and classes and everything. So I've seen a big improvement. Everybody individually, but as a family, like teamwork, pretty moving. Congressional leaders, federal agencies, and private foundations recognize the need for a national effort around juvenile justice, just as had been the effort around child welfare. And that's when the the juvenile justice model court based on the resource guidelines for juvenile justice were developed. And the initial focus of the project was the initiative to develop, refine, publish, and disseminate the guidelines. We were, I think, the first juvenile justice model court because we had a dynamo of a presiding judge who said, I want it, I want it, I want it. It's a fantastic set of guidelines. Was developed in 2005, and it's very similar to the model court project for child welfare, which is key principles and ways to work to better the system. You have got to have your whole court involved, and it's an amazing effort to have probation, to have law enforcement, educators, behavioral health, domestic violence, everybody at the table to make important decisions about how the system will be run. I joke that when you have a model court, when you're really doing good active engagement and collaboration, you don't change the color of the paper that you're writing on without everybody's voice. And that's exactly what we do at juvenile court every time we talk about an issue. I'll end by telling you how that applies in terms of bringing all of what's been said together in one place. I did announce when I became the presiding judge that I believe strongly in the one court principle. We are a juvenile court, unlike many, where everything is in one place, literally, including a 24/7 detention facility. So we have probation, we have a child and family services division. Everybody is there. It's just that nobody knew what anybody else was doing. We had a model court working group on dependency, a model court working group on juvenile justice. We had our family law protocols, and you could barely find anybody who knew all the work we were doing. I started inviting members of the two work groups to attend each other's work groups. And finally, what we did this year was we developed a one court goal of working to do a better job around domestic violence, regardless of how someone came into the court. Whether it was a child welfare case, a juvenile justice case, a family law case, we were going to work on making sure we had the same definitions, that everybody was educated, and that we were all advocating for effective interventions for our children and our families, regardless of why they were there. It's been an amazing process. The three co-chairs are me, the head of CPS for our region, and the head of juvenile probation. So we made it very clear that it's a top-down effort. And we have committees that are very carefully and strategically developed with representatives from probation, child welfare, behavioral health. They're the ones who provide all the treatment in our state. Educators, law enforcement, limited jurisdiction judges, all of whom have been trained at the Institute through the council. And I think we're going to do great work. It is a huge task. And we are refining and trying not to go in too many different directions. But it's because we were trained by the council, it's because we believe in the principles of well-trained judges and collaboration and bringing everyone to the table before making important decisions about our children and families. Thank you.
Thank you very, very much. Ladies and gentlemen, I know we are running very, very tight on time, and I do apologize for that, but I do hope that we've been able to demonstrate to you, my friends and I, how the council is instrumental in making certain that the precious federal dollars that are submitted to the state and given to the state through various programs are being used efficiently and effectively to help protect our children, keep supporting our families, and keep our family units together for our children, not only in the foster care system, the juvenile justice system, and our family courts throughout this nation. I do want to see if there are any urgent questions that we can take together as a group. If they're not, certainly we are available to answer questions after we dismiss this morning. Does anyone